Hi everyone, welcome to our webinar this morning. So today's presentation is around financial agreements and particularly are they worth the paper they're written on. So my name's Carly, I'm from Community Legal Centres Queensland. Before we get started, I'll just make sure that everyone can hear me. So can you please press the button that looks like a hand on the control panel, and that way I can see that you guys can hear what we are saying. All right, so it looks like some hands are going up, so I think that we're good to go. So firstly, I'll do the acknowledgement of the traditional owners of the land on which we're holding this webinar. So today in Brisbane, they're the Turrbal and the Yagara people. I wish to pay my respects to their elders, past, present and emerging, and acknowledge the important role that Aboriginal and Torres Strait Islanders continue to play in our society. As this webinar is being viewed by people across Queensland and Australia, I'd also like to pay my respects to the traditional owners of the land throughout the country. So today, as I mentioned, we've got Philip Sorensen here, who's a barrister and an accredited family law specialist. So he's going to be speaking to you about financial agreements, especially in light of a recent High Court decision. So today's webinar is going to be recorded, and we'll put the recording up on our website together with the PowerPoints and Philip's paper, and the paper and the PowerPoints are also in the handout section on your GoToWebinar control panel. So as per usual, we'll hold the questions over to the end of the presentation, and that I'll talk you through the ways that you can ask questions when you get the chance, okay? So without further ado, I might hand over to Philip to get started. Thanks, Philip.
Thanks very much, Carly. Good morning, everyone, and welcome along to the webinar. And as Carly's indicated, the technical paper is available, and we'll use the slides for the purpose of the presentation this morning. So just to set the scene, looking at financial agreements, your favourite client comes in to see you, is thinking about getting married and wants a prenup. So what is there to worry about? Now, just to look at financial agreements in history, it's important to look at the fact that they have only been around since December 2000, and there's been a lot of litigation since. Why are they important? Firstly, for people, whether they're in marriages or de facto relationships, when they separate, they can reach a financial agreement, or in the case of a prenup, reach an agreement about what they might do in regard to their property if they do separate. So the three important aspects: firstly, to add certainty to those arrangements, ensure that the arrangements made are legally binding, and importantly as well, to invoke a number of concessions that are available under the revenue laws. That includes transfer duty or stamp duty, capital gains tax. It's essential for these agreements to be final, so once the agreement's been carried into effect, there can be no revisiting of the arrangements that has been reached. Now, perils apply for both the parties involved and their lawyers if the documentation is ineffective, as can be seen from the High Court case of Thorne versus Kennedy that Carly's mentioned. These things can take a long time in the courts. It's difficult to predict with certainty what approach the court may take, and it'll be interesting to examine the changes with Thorne and Kennedy. So the paper's technical, and really we can only, in the time available today, give an overview, but to have a brief look at financial agreements, what do laws say, how can we attack them if you're involved in a court case doing pleadings, how you might set aside agreements and some of the aspects of setting them aside, and impacts on enforceability of them, and some lifestyle clauses, a discussion about those. So having a bit of a look at financial agreements, what is the question? This is a topic to look at in terms of the history. These things are commonly called BFAs, or binding financial agreements. The way I look at it, those are terms to be avoided, with apologies to the Prince of Denmark, of course. Firstly, because that term's not used in the legislation. It's the main question today is whether these agreements are binding. So they're financial agreements, and they were financial agreements right from the start. Lethbridge Senior Counsel talked about them in the sense of having regard to the frequency at which they're being set aside. So they're really not binding financial agreements. The question is the agreement binding? Those terms aren't in the Family Law Act, and that's the way I tend to look at them. Okay, so just looking at the current law developments in regard to agreements, really in the early years, the complaint about financial agreements that arose was the technical aspects of them. That is, people got the technical aspects or the references to the sections wrong, the annexed legal advice certificates incorrectly named the parties, and you'll see a reference there to Senior and Anderson. So it became a trend of solicitors in New South Wales not to do the financial agreements, and you might have seen recent press around Kennedy and Thorne to that effect. So the technical aspects, things were too hard, the scope to set aside them was large. So there's much scope for legal action against legal practitioners who draft the agreements or advise on the agreements even. And anecdotal evidence suggests, of course, that they're alive and well and flourishing around the place. However, Professor Wade saw drafting financial agreements as a very risky business. I've set out at page 7 of the paper the quote there, and I think it's pretty harsh stuff, because he's saying there that inexperienced and smart family lawyers will never draft a prenuptial agreement or during relationship agreements, and they'll send their clients off to naive or risk-taking lawyers. So that's pretty cutting, isn't it? So he's saying the potential for the action for professional negligence is quite dormant, lays there like a landmine. I think it's maybe like a hand grenade with the pin taken out and you've counted to 9 and they hand that over. The main thing is that these agreements, because they lay dormant, the issue that arises might occur, say, 10 years down the track from the time the agreement's entered into, and it's probably the last thing you want as a lawyer when you're just about to retire, is to have somebody send you a claim in court about an agreement that you advised on or drafted 10 years ago, 15 years ago, because it simply takes that long to for parties to separate and then for issues to arise. Okay, so if we look at then that task of how we might attack a financial agreement, I've referred at page 8 of the paper to St. Clair, where Justice Ryan talked about a particular pathway in considering a financial agreement. And the first thing is to look at whether there is a financial agreement. If that question's answered in the affirmative, should that agreement be set aside? Is the agreement binding? And then is there a pathway for the court to exercise the discretion under section 90G1A, and how the law might apply to that? And if so, how might an agreement be enforced? So I think there are 2 or 3 ways to look at an agreement. Firstly, to look at the technical requirements. Then, can the agreement be set aside under the laws of contract, or can it be set aside on an equitable ground? Older practitioners might, of course, remember the old Section 87 agreements, which required a court order to approve them. So the issue is that a financial agreement is a private agreement. It's a private ordering of the parties' rights. So ordinary contracts in commercial spheres don't require court orders or registration to come into effect. So financial agreements are really in that same boat. Now, why there are strict requirements for the agreements to be binding is the consequence that the agreement will oust the jurisdiction of the court to make property settlement orders. So Is the agreement a financial agreement? I've set out there the technical details of section 90G, and you can go through that. That's the main section that we look at to see if an agreement has been compliant with the legislation. And I have highlighted there that the agreement is binding if and only if the requirements are satisfied in section 90G. So that is a technical requirement. It means what it says, and it's significant because non-compliance with that legislation can be fatal. So if we look at the types of agreements that can be entered into, there is the first type of parties who are entering into a marriage, and that's the prenup agreement. The second is one made during the marriage, section 90C agreement, and the third is the agreement that's made after the divorce, or a section 90D agreement. Okay, so now I've set out in the paper the requirements of page 11 of the requirements, and we'll skate over those to an extent. But in 90G, in summary, requires that you firstly got to have a written agreement signed by the parties. You've got to have independent legal advice. That's got to be provided by a legal practitioner. The advice has to deal with the rights of the parties and advantages and disadvantages of making the agreement, and it must be provided prior to the parties signing that agreement. Then there's requirements for signed statements about that advice to be exchanged. So if we look at how to set aside an agreement, even if an agreement complies with all of those technical requirements, it may nevertheless be set aside, and section 90K of the Act is the main section which details those circumstances. So that includes things like if the agreement is obtained by fraud, if an agreement is void, voidable, or unenforceable. Now, those are called the vitiating factors, and you'll see later on how those factors operate. So the general common law and equitable principles apply to setting aside agreements, and the principles of contract law, those include misrepresentation, undue influence, mistake, and duress. It's important to note that the Act itself provides a limitation on the remedy for unconscionable conduct to the time of making the agreement, and that makes sense. Okay, so we might look at in the next section then pleadings to set aside financial agreements. You may know that the federal courts, the Family Court and Federal Circuit Court, that deal with financial agreements are not pleadings courts, but effectively matters are brought before the court based on an application and an affidavit system. So there are many complexities, of course, in these types of claims. So in order to identify the real issues, the best way, in my view, to approach the court is to ask for an order for pleadings or points of claim to be delivered. Now, if there's a dispute about an agreement, that approach can lead to significant cost savings for the parties. Because there are no set rules for pleadings, the courts have power to regulate their own proceedings, and that can be done by way of a directions order, and that's a quite sensible procedure, as Judge Howard outlined in Park's case. So once those directions have been complied with, the matter can then come back before the court for a directions hearing. The court can consider the points of claim at that stage, and interestingly, indeed, whether an application can be made for parts of a document to be struck out. So in other words, a particular case might deal with aspects a party may raise that are aspects of duress or unconscionable conduct or undue influence, and the court may decide to strike out various parts of those points of claim or a statement of claim, and that can then narrow the issues, and that can involve a significant cost saving. So the final hearing can be embarked on with clarity, really. Now, points of claim and statement of claim, they're slightly different procedures. Points of claim are something which is less strict procedure than a pleading. Now, the federal court rules do provide for the pleading rules in Part 16, and that's a material facts model. And in a case where you want to apply the strict rules of pleading, it's appropriate to apply for an order that there be pleadings delivered in accordance with the federal court rules. Now, I've set out in the paper a case of read and read. That's an example of where there are points of claim, and an application was made in that case to join the solicitors with claims under the Fair Trading Act and Trade Practices Act. So the judge then embarked on that application, not only in regard to the agreement, but against the solicitors by requiring the filing and service of a claim and statement of claim. So in that agreement, in that case rather, the respondent claimed the agreement was not a binding financial agreement, and on the basis she didn't receive independent legal advice. So those are an example of how you might proceed. St. Clair is another case there, and I've extracted there some comments the full court made about the particulars of claim that the wife put in there. The court described it as being a manifestly inadequate document, so it was unparticularised and not very helpful to the court. So that's why you might think it's important then to have a much more strict procedure. So I've suggested in the paper that because the family court is a federal superior court, that it's more appropriate to apply the federal court rules to any order for pleadings. However, I don't think the courts are necessarily in favour of that, and it seems that the points of claim procedure is something more that the court will look at, in particular in a family law case. So we'll move on then to talk about how we might attack an agreement and look at some of the aspects there. Now, the first thing to think of, and I think it's important, although a lot of the discussion is about equitable principles in regard to financial agreements, to understand that first and foremost, they are a form, financial agreements are a form of contract. So the traditional form, and of course in contract, is to look at whether there's been an offer and acceptance. And you might also find in your practice another factor, even one step before that, which is to look at whether or not parties actually have capacity to enter into a financial agreement. So that is something which may come up, and it may be that a person, for example, consults you who has an attorney. They might have an enduring power of attorney, and there might be doubts and issues about capacity. So I think that's something to just keep in mind as well. So if there's no offer and acceptance, a contract can't be formed pursuant to contractual principles. I've distinguished there the concepts of an invitation to treat, how that's distinguished from an offer, and the tender of a document purporting to be a financial agreement by one party to the other may constitute an invitation to treat and not an offer. An example of that might be a case where you receive a letter, or you ask to advise on a letter sent from a firm of solicitors which includes a financial agreement as an offer to settle a particular matter. So you need to very carefully look at how those documents are presented. Now, Sullivan I referred to there is a very important case in regard to issues around financial agreement and when it might be accepted. And it's important to know that a financial agreement cannot be both a Section 90B agreement and a Section 90C agreement at the same time. An example of how that might act or happen in practice occurred in Thorne and Kennedy, which we'll talk about in detail later. But in that case, for example, the parties entered into a Section 90B agreement prior to the marriage. They got married, and then straight after entered into a Section 90C agreement. So Sullivan is a good example there of a case where 2 days before the wedding, the wife signed the agreement in the presence of her then solicitor. The husband later on executed the agreement in the presence of his solicitor on the 16th of April, 3 days after the parties were married, and that was the issue then that arose. So I do point out there in the paper that it's not a mere matter of when a document purporting to be a financial agreement is signed or is dated, that it's a question of when the agreement was made. And I've extracted Section 90C there, so the issue is around the time of making the agreement. So it's important to examine all the facts and circumstances. It's interesting, I think, if you look at some of the financial agreements, particularly the due date when they're signed, people might date a document as they normally do at the top with one date, but it's not often that you'll see in the due date or the signing clause the actual date that the party signs the agreement. I think that is very important evidence. You should also keep evidence in your files when you're advising of when you see the client, obviously the advice that you give to them. But I've certainly seen in some cases that the solicitors haven't even kept notes of when they saw the client to sign off on the agreement. So all of that evidence material is actually critical to determining the existence of the agreement. I've also set out there at page 17 of the paper that an offer is not effective until it's been communicated to the offeree. An offer to sell something is nothing until it's received. Particularly in the way that we're used to dealing with contracts, we tend to think about the communication and acceptance of an offer as being automatic and happening at the same time. But it's not automatically communicated. There's got to be evidence of that communication. An example might be where somebody hands a draft financial agreement in a sealed envelope and doesn't tell the other party that it's in that envelope. So when is that received or when is that communicated? So I've set out in the paper as well some extracts from Sullivan about an offer made during the marriage but not being accepted and no counter offer being made. So in that case, the parties didn't get to first base as the court held that there was no agreement existing between the parties. And even though it seemed that the case was about that 90B, 90C issue, the judge found that it was not necessary to determine whether Section 90B or 90C were applicable to the agreement, as there had been no agreement entered into between the parties. So that's why I say that you need to be very clear and get the evidence about offers and counter offers. And often in a financial agreement, if it's being negotiated, there will be counter offers about various different clauses, and sometimes those counter offers might be in handwriting as well, so it's important that that is very clear. Okay, now you'll see on the slide that question arising about does an agreement have to be fair and reasonable, and at the footnote on that page I've set out a paper by an extract of an article rather by James Gerard, who writes in The Australian. He's recently written about Thorne and Kennedy. Talking in his paper was that a prenup proves to be a capital idea, and this is only last year. So the premise of that was that the agreement has to be fair and reasonable. Does that have to be so? So it's commonly thought that an agreement must be fair and reasonable, and that is now a question, is that actually the case now? So I've set out some of the technical words in regard to the provisions of Section 90K and 90G1AC, and you'll see the reference to the bracketed words disregarding any changes in circumstances from the time that the agreement was made. So a court can declare an agreement to be binding if it would be unjust and inequitable if it were not made binding, disregarding changes from the time that the agreement was made. So in the paper, I've set out the history of the discussion in Holt and Holt, which is one of the most important cases in that area. I'm not going to go through that in detail, except to, if you look at the paper at page 20, there's an example given by Justice Murphy, and he was the trial judge in that particular case. So he looked at criteria, whether or not the bargain offended ordinary notions of fairness or would fall out of the range of a broad assessment of the Section 79 discretion. So Justice Murphy's given a very good example, I think, of a 40-year marriage, no unusual features, and a financial agreement that provides upon the breakdown of the marriage, the wife is to receive 4% and the husband to receive 96%. So you might think immediately, well, that doesn't sound particularly fair. So the full court disagreed with Thackeray J in looking at the issue of fairness or unfairness and said that the trial judge had misdirected himself, and the terminology is confusing, I think, because it doesn't refer to whether the terms of the agreement are unjust and inequitable, but rather whether or not it would be unjust and inequitable if the agreement were not binding. So how confusing is that? So I've also referred to the case of Fuster and Drake. Now, it's very important then to look at how the High Courts looked at this in the case of Thorne and Kennedy, and I've set out on the screen the extracts of paragraph 55 and paragraph 56 because the High Court considered that the matters that the primary judge referred to, that is, the agreement as not being fair or reasonable, was not merely open to the trial judge but was an understatement. So I think that's really clear that the solicitor in that case gave unchallenged evidence that the terms of the agreement were entirely inappropriate and wholly inadequate in relation to everything. So I don't know that you could get a much broader scope there. So in that case, the oral evidence of the solicitor was that it was the worst agreement that she'd ever seen. And there, pretty clear example that it couldn't have operated more adversely to Miss Thorne in any way. So the High Court at paragraph 56, which I've got up on the next slide, then sets out some more detail about how that might operate, and stated clearly that the judge was correct to consider unfair and unreasonable terms of a prenuptial agreement and postnuptial agreement as matters relevant to the consideration of whether the agreements were vitiated. The High Court's careful to note, I think, that the agreements of this type, by their very nature, will usually be more favourable, sometimes much more favourable to one party. However, despite that, the usual financial imbalance in agreements, it can be an indicium of undue influence if it is signed being known to be grossly unreasonable. So I think that it's something to keep in mind, but on that basis, the fairness or unfairness of the agreement may well now be a consideration, certainly as to whether a financial agreement is vitiated. So moving on and look at another topic, which is statements of values of assets and liabilities in financial agreements. So one of the grounds that a party could plead is that another party has misrepresented their position in regard to assets and liabilities. So it's until, in fact, in the forecourt in Kennedy and Thorne explained that, as I've set out later on page 23, there were erroneous views about whether an obligation of disclosure arises in regard to a financial agreement. And that comes from the fact that there's no requirement in the legislation for that disclosure. So it needs to be distinguished, though, between that obligation and whether or not a non-disclosure can amount to misrepresentation, as we'll see there. And as Judge Howard talked about in Park and Park, it will depend on how a court views the obligations of the parties. So it's common for financial agreements to set out schedules detailing what parties say their assets and liabilities are. And in my view, that needs to be done exceptionally carefully. If estimates are given, then it needs to be clear on what basis they are estimated. It needs to be clear if it's based on evaluation or not based on evaluation. Now, I've set out some other information there in the paper about the need for clarity around the pleadings and the contentions about that, and as I've just referred to, marking estimates clearly as such, and the understandings of the parties about how the values have been arrived at must be set down. That, of course, is quite a different concept to the complete omission of an asset, and that would be if, for example, as occurred in one case, somebody's not mentioned that they have an asset such as a unit, or superannuation as occurred in Park. Another ground to set aside a financial agreement can be based on whether it's impracticable to carry out, and Sanger is the case which I referred to there in the paper, and also the case of Gregory, but I'll leave that for you to have a look at later. So duress is mentioned there, and we'll have a look at that in a bit more detail, but parties may wish to attack an agreement on the grounds that their signature was obtained as a result of coercive behaviour amounting to duress, and the High Court in Thornton Kennedy has gone into that in some considerable detail. I do mention exclusion of liability clauses because often a clause might be put into an agreement that seeks to exclude liability about disclosure or waiving right to absolute disclosure. I sound a cautionary note there because such a clause in regard to a misrepresentation will not affect a fraudulent misrepresentation, but it may affect an innocent misrepresentation. Okay, now time is going to be short, so I'll try and move through the rest of the paper as quickly and as effectively as possible. And perhaps what I might try and do is concentrate a bit more on Thornton Kennedy because that's of topical interest, but to then look at the various aspects of interest in setting aside the agreements. And as I indicated before, contract is the first port of call, and I've set out in the paper how the remedy of rescission applies, and common law allows contracts to be rescinded for fraudulent misrepresentation, and duress, and the relevant section I've set out there is section 90K. KA. So that gives the court the power that the High Court has in respect to contracts. So I've set out in the paper how a contract might be voidable for misrepresentation, and it's important if you're looking to attack an agreement to look at where there might be a misrepresentation. I think it's common, as we've just discussed, for the schedule to look at assets, liabilities, superannuation and resources. So that's something to look at, and where you would first look at to see if there's any misrepresentations in regard to those matters. I've set out the elements of misrepresentation for you in the paper at page 29, and when a representation has to be acted on. So it's important that there must be reliance, though. For example, if a party would have entered into the financial agreement anyway without any of the particular details in the agreement, and there is no reliance and there is no case. So I've said it's an interesting in the family law context, because in the case of a prenuptial agreement, the acting on the agreement could be considered to be the act of entry into the marriage, so there must be reliance on that for entry into the marriage. So the materiality, the representation must be of a material fact. So that's something that grounds the application. In other words, it's got to make a difference. I've also set out there about non-disclosure, and I refer there to Justice Brereton's paper, Equitable Remedies and Rectification of Financial Agreements. That is a seminal paper in this area and very important, and I commend that to you to grab a copy of that paper and read it through. Do, however, bear in mind Thorne and Kennedy, of course, when looking at any of those aspects. Now, I do refer as well as mistake, difficult part of the contract law, and that can be a grounds of setting aside the agreement. And as one of the authors of the text refers to, it's probably in most contracts that at least one party is at least mistaken to some degree as to the extent of the benefit will provide. I suppose it's not quite the same as saying I made a mistake when I married him. So Sullivan's a good example. Justice Young referred to Senior and Anderson in that case about aspects of mistake. I apologise if my Chinese pronunciation is not good, but Fac and Zhu is a case I referred to there with Justice Benderman. It was an interesting case because he referred to it as an all duck or no dinner dispute for the parties. It was a terrible case really because the parties, whilst they had a complicated financial history, were the victims of an elaborate fraud. So an asset that they thought was there and which they'd invested $420,000 turned out to be a mirage. So that's an example of a mistake. So the big topic for the day is setting aside financial agreements in duress and grounds of undue influence. I've set out in the paper there at page 34 that one of the main vitiating factors in equity is duress, and that is an aspect of contracts which are entered into as a result of serious threats, and it often involves a serious threat, proper threat to do something generally which will be unlawful. And in duress, it's talked about as being a proof of improper pressure. Now, I've set out some of the cases there of Fuster and Drake and in Thorne and Kennedy, and I've extracted there at page 36 the facts of that particular case, and might be necessary for you to have a look at that in more detail later, but in that case the parties had met over the internet. The wife was 36 and the husband then aged 67. She had English language skills but informally acquired. Obviously there was a great disparity in their income. He was a property developer worth at least $18 million. So the issues in that case came down to the agreements, and there was one, as I said earlier, entered into before the marriage and one after the marriage, and they provided for various payments to be made to the wife, and the important thing was about the advice that had been given and the husband telling the wife that if she failed to sign the agreement, the wedding would be off. So the wife's solicitor advised her orally and then in writing not to sign the agreement. There were reasons, several of those, including that it was all in the husband's favour. It was indicated later it was not in her favour. And so the parties then came into dispute, and Judge Damac in the Federal Circuit Court found the agreement was entered in under duress, and the first agreement, the second agreement was a continuation of that, and that was then overturned on appeal to the full court of the family court. So there's certainly a lot of detail there for you to consider, but in arriving at its decision, importantly, the full court determined that the fact that the husband had required the financial agreement to be entered into before the marriage could not be seen as a finding for the basis of duress. So the real difficulty for the wife, the forecourt said, in establishing duress was that she'd received independent legal advice, was advised not to sign the agreements, but went and signed it regardless. So it's important then to look, and I've extracted the basis and the forecourt reasons there at 159 to 169, which is valuable reading. So the High Court overturned that decision, and in regard to duress, decided and maybe sidestepped that question about the aspects of duress, finding it wasn't necessary for the judge to consider common law duress, but interpreted it that the sense that the primary judge described the pressure was to focus on a lack of free choice, in that sense used in undue influence cases rather than whether Mr. Kennedy was the source of relevant pressure. So if we look at undue influence, which is the next part of what the High Court looked at in the time that's available to us, and I've set out in some detail aspects of undue influence and the history of that. The High Court thought that no court had ever attempted to define undue influence, but it really is the doctrine of equity pursuant to which a court can set aside a transaction unconscionably procured in the consequence of the relationship of the parties. There are two different types. So there are those relationships that raise a presumption of undue influence, the presumed relationships, and other relationships in which there was a presumption but proof of the aspects of the relationship may cause undue influence to be inferred, or a proved relationship. Now there's some consideration there in regard to the relationship, and particularly in the relationships of people who are engaged to marry, and I've referred to some of the High Court cases there in Johnston and Buttress and Luth and Diprose, Yerke and Jones, to give you a history. Those cases are picked up by the High Court in the decision. Justice Barrett in the paper I referred to thought that it was probably the case that that relationship, or the better view was that it's a presumed relationship. However, the High Court looked at cases, and you'll refer the reference there to Zammit and Hyman. I'm up to page 42, and in rejecting the submission of Ms. Thorne, the High Court said that common experience of today, with a wide variety of circumstances in which two people can be engaged, negates any conclusion that there is a presumption of that undue influence. So I think that's pretty important, and the High Court's rejected that clearly now. And in my view, as I've said, I think the court's dealt with that conclusively in bringing the law up to date with the times in reality. Okay, so I've set out some of the cases on undue influence, including St. Clair and Piper and Mueller and Raleigh, and also Thorne and Kennedy and Wood and Grover. So that's something to look at in terms of the historical aspects. Now, though touching on it lightly at page 48 and 49, I've set out some of the factors that may now have prominence in regard to this consideration. And bear in mind that the High Court has referred to, in the Thorne and Kennedy, some of the very important aspects of how to prove undue influence. The court has to look at a very careful consideration of the facts, and because equity looks very much into the detail of all the factual circumstances, it's important to look at that clearly. So those grounds include whether the agreement was offered on the basis that it was not subject to negotiation, whether the emotional circumstances in which the agreement was entered into included any explicit or implicit threat to end a marriage or end an engagement, whether there's any time for careful reflection. Now that's a good example there of how far ahead you might need to present an agreement for there to be careful reflection. somebody suggested that that might be a period of 2 weeks in one of the newspaper articles that I've seen. I think that's probably a bit too short in timing. Most of the American cases on these agreements are called the ink on the wedding dress cases. So careful alteration, in my view, should mean in reality, if there's going to be a financial agreement presented, it has to be before the invitations go out, not as occurred in Thornton and Kennedy when the bride's parents had just arrived. So relative financial positions of the parties and the independent advice that was received, and whether there's time to reflect on that advice. Although, interestingly, note in Thornton and Kennedy, of course, that the solicitor's advice could not have been clearer, yet still that was one of the aspects that the court considered. However, the court decided in the High Court that that agreement was to be set aside. I've set out in the paper some of the remedies for undue influence, which I'll leave you to look at in your own time. And so that's something that will need to be considered perhaps for the future. The most common remedy, of course, in a financial agreement case is to set aside the agreement and then proceed ordinarily under Section 79 or Section 90 SM if it's a de facto relationship. But we'll wait and see whether some of the other remedies, such as equitable compensation, do take off. They may not. Okay. I've set out in Part 6 some of the impacts on enforceability and third-party interests. So that's something perhaps to look at later on as well, but that's third-party interest might be in terms of a third party such as a creditor. Now, agreements to be enforced, the agreements need to be clear, and you'll often see applications to court these days to enforce agreements. So aspects of whether the agreement is clear, how it's to be enforced, and whether it can be enforced will come up in consideration of the agreements. Now, I've looked at some lifestyle clauses in Part 7 of the agreement. This might be some of the best fun that you can see in regard to financial agreements, but it is a trend apparently in the United States for agreements to have a so-called lifestyle clause, trying to put restrictions on what parties do. I've said there seriously could be you restricted from watching MasterChef or whatever the new TV show might be. And I've set out some examples of those sorts of things. So interesting to see whether people would try and restrict the spouse from how much time they watch TV, dieting, how much weight you could put on, what happens when you have children. I put that picture in because I think those kids are particularly cute. And obvious things, for something serious, a child's education, there are disputes and children sometimes litigate choice of school for their children. Now, any of those debates around the children's education can be damaging, and there is certainly one thing our judges hate probably more than financial agreements, and that is to decide what private school a child might have to go to. So you can have other lifestyle clauses such as non-smoking or the use of drugs. I think in looking at the legal position, I've referred to a case of Gibbs that the reality of the so-called lifestyle clauses is a matter that will be subject to enforceability, and that's going to be the real issue in regard to whether or not the clause is enforceable. So I think the reality is that the legislation is structured around financial agreements to deal with property maintenance and not for lifestyle matters. So it'll be a matter whether that clause can really create a legally binding relationship and be enforceable. In my view, they are not. It boggles the mind, as I say there, to think of how some of those lifestyle clauses might be enforced. And I've heard that some people might well try and have lifestyle clauses as a separate type of agreement or a side agreement. So it remains to be seen. I've got some contacts in the United States, and I've referred to Jolena Lewis there. I do refer to her website there if you want to look up Jolena's site, but in New York she practices and says that those clauses are rising in popularity, I suppose. The most common clauses regarding an infidelity, and she referred there to the practical difficulties in proving that. Is chatting with an old boyfriend on Facebook considered cheating? So it might be helpful for a couple to have the rules set out in writing, even if they know it may not be enforceable in court. Okay, so we've got about 5 minutes to go, so we might then look at some questions. I referred to the case there of Park and Park, and there's a full extract of that particular case. That's a really interesting case by Judge Howard, and it does deal with fraud, unconscionable conduct, undue influence, uncertainty, repudiation and rescission. Quite interestingly, it looks at some aspects of domestic violence and how that might have affected the relationship. So I do commend that to you. It's a very interesting case. Judge Howard has gone through all of those aspects, although not deciding on the unconscionability aspects because it wasn't pleaded. He also refers to some suggested clauses that might be helpful to look at, including that the agreement was then limited to be operative to only certain of the parties' assets and liabilities. And so I think that's really quite a helpful decision, but time doesn't allow us to go through that in any detail. Carly.
Fantastic. Thanks, Philip. That was really helpful. And, you know, I think I really encourage everyone to read the full paper because there is a lot of information in there and a lot of important detail that we didn't really get time to cover today, unfortunately. So we'll go to questions now. So there are two ways you can ask questions. You can press the button that looks like a hand and we'll see a hand go up on our end. We can then unmute you if you have a microphone and let you ask your question that way. Alternatively, you can type your question into the question box and we'll see the question come up and I'll read that one out for everyone to hear. So we've got some questions already coming through. So we might start with that one. So Philip, is it safer as a solicitor to focus on BFAs after separation?
I think the answer to the question, thanks Paul, is strictly speaking yes. But I think that all agreements for all of the reasons have risks attaching to them. One thing which I didn't quite touch on in regard to, and Professor Wade talked about that in regard to agreements, is the fact of that you can't control what another person does. And I think the common thing, well, I'm not sure that Professor Wade called it necessarily a delusion, that is, you don't know what the other party's going to do. I gave an example there of a solicitor sending out an agreement as a first offer and fully signed by their client. Now, in my view, that's a straight fail from the start because the solicitor could not have gone into any detail about disclosure of assets and liabilities. You've mentioned there that that Lexon have a kit including the agreement letters of advice. Not aware if those had been tested. I haven't actually seen those documents. So bear in mind what the High Court said, of course, in Thorne and Kennedy may widen the scope for the agreements to be attacked.
Okay, great. So another question that we've got here is, can you tell me why it is we're seeing firms asking for BFAs to be prepared dealing with spousal maintenance only alongside consent orders for property?
Okay, well, I think that's a really good question, actually. The if you think in terms of a financial agreement as a as a shield rather than a sword, and in that case you might wish to enter into consent orders in respect of a property matter, and then that's the sword, I suppose, to carve up the property, but to have a financial agreement in place which prevents a claim for spousal maintenance being made. Now, bear in mind, of course, that there are other restrictions there on agreements if a party is on an income-tested pension allowance or benefit. Carly?
All right, so there's another question here, maybe a bit of a controversial one. So One Nation political party was once reported to have as one of its family law policies to make prenup agreements compulsory for everyone getting married. What do you reckon about that?
Well, Carly, thank you for that question. It is a rather controversial one, isn't it? So it might well change aspects in regard to, I suppose, aspects of unconscionable conduct and duress, because if everyone was required to enter into an agreement, then that would evaporate any issues around them being compulsory. So it's interesting, and anecdotally, as I understand it, some of the civil code type countries have a requirement that parties enter into those agreements. So it's not a new concept. And for example, I understand I'm possibly wrong, but maybe South Africa, maybe in France and some of the continental countries. So I think that would be a very interesting development, and we wait and see whether that's then brought into any legislation with the changes.
Very interesting. So I've got a comment here. The old adage for BFAs that a client can enter into a bad agreement has then been overturned with the fair and reasonable agreements. Would you say that's the case?
Yeah, thanks, Paul. I think you've got to look at that, and that's what I've set out at Thorne and Kennedy at paragraph 55 and 56. I think read 56 very carefully. I don't think it's a blanket coverage, but in my view, it's one of, as the High Court said, one of the indicia to be taken into account. And I think if you look at that section or that paragraph, it's a bit like the oracle at Delphi, isn't it? Once you get the advice, it'll take some time to really understand what it means. But I think if I could put it this way, it's a bit of a sliding scale with that, because it is certainly the policy that parties can privately enter into these agreements, and they may be unfavourable. So I don't think it's going to be black and white yet at this stage. Thanks, Paul.
So do you consider that a financial agreement is a more certain way than consent orders to finalise spousal maintenance obligations?
I think that comes back to the point of view earlier that we talked about there with a consent order, and a consent order in the section 77A clauses, and I think even specialists will probably disagree about what they mean. My view would be that a financial agreement is the way to end a spousal maintenance obligation, but it depends on that agreement being upheld for all the ways that we're talking about. And bear in mind, as I said again, about the test of a person cannot support themselves without an income-tested pension allowance or benefit may mean that they can still bring an application, subject, of course, to the relevant time limitations. Okay.
So we've got another one here. Do you think that the High Court decision in Thorne and Kennedy will mean the end of prenups?
Yeah, that's a very broad question, Carly, I think. I think the answer is probably no. I think, as with these agreements, there is always the uncertainty that attaches, and maybe it's now more uncertain. I think that you've got to turn it over the other side and look at it from the point of view, well, the agreement may well be upheld, and it might well be very good insurance to have one of those agreements in place. So, no, I don't think it's the end of prenups, but I think life has become a little bit more uncertain.
Indeed. So, got maybe 1 or 2 minutes for any last burning questions you may have. So please do type them into the question box while we've got Philip on site. While you're typing those questions, did you have a comment there, Philip?
Well, I think in looking at all of the issues with the agreements, I'll come back to an article by James Gerard in the Australian only last weekend or the weekend before, and he talked about those, and he thought that prenups will continue to be common after the ruling, but from a financial perspective, the most obvious advice is to try and stick with marriage and avoid divorce, noting, of course, that's easier said than done. And perhaps I might just leave you with his comment from the late American actor Zsa Zsa Gabor, who used to say, getting divorced just because you don't love a man is almost as silly as getting married because you do.
Excellent end note, I think, there. So from everyone wildly clapping and cheering out in their chairs, thank you so much, Philip, for coming in today and presenting to us on financial agreements. As I noted earlier, we will have a recording of this webinar up online a little later this afternoon. So if you didn't get a chance to tune in today, please do have a look at that as well as Philip's paper. So thanks everyone for being part of our webinar series for today. We've only got, I think, 1 more left for the year, so please have a look on our website and for details of that one. Thanks everyone.
Thanks, Carla.